As a judge, he's generally someone you don't want to find yourself facing, but ask anyone that works in the Supreme Court and they'll tell you Justice Graham Heiley is one of the nicest blokes on the bench, now deciding the time is ripe to step down.
It's time to do something a bit different, like maybe sleep in the mornings.
A well-earned sleep-in after a 50-year career in the legal profession, the last 8 as a judge. In his earlier days as a lawyer, Justice Heiley worked on native title claims right across the country.
One of my highlights, I've had a few highlights, but particularly where I think that I've helped the Aboriginal people get their land title.
He also assisted in the first boatload of asylum seekers from Cambodia, pro bono.
It's one of those great things where you had all of the barristers joining together to help these people.
Through the good cases and the bad, there's never a dull day in court.
You know, occasionally there's just some cases that you have to go home and laugh about or tell your mates about.
Dealing with murders, rape cases and everything in between. It's grim work, even for a seasoned judge.
I guess you get a bit hardened to it after a while and you have to go home and put it behind you.
Although the work never stops, Justice Heiley often working around the clock.
I try not to work on weekends in here, but I'm always taking stuff home every night. But at least 2 of the other judges, if I come in on a Saturday or Sunday, they're always here. There were 6 judges way back in the late 80s, and there are still only 6 judges. And the listings have tripled.
The average time a matter takes to progress has more than doubled over the last 6 years, from 125 days in 2014 to 300 days now. Justice Heiley issuing a plea for an extra judge on the bench as he prepares to bow out, although his retirement will deliver an Australian first. The gender balance of judges in the NT will be even. Sarisha Bradley, 9 News.
All persons having any business before this Honourable Supreme Court of the Northern Territory, now draw nigh and give your attendance, and you shall be heard. God save the Queen. Please be seated. A ceremonial sitting to mark...
Mr Nikolai Kristrup, SC, Solicitor General for the Northern Territory. Mr Ken Fleming, QC, Independent Commissioner Against Corruption. Mrs Gemma Lake, Acting Chief Executive Officer of the Department of the Attorney General and Justice. Ladies and gentlemen, the Attorney General, the Honourable Selena Yubo, is presently in Gapawiak, has also asked me to register her apology. As you're all aware, here today the court is sitting to mark the retirement of Justice Heiley. Justice Heiley was sworn in as a Justice of this court entering Queensland bars. While the speakers here today will have more to say about His Honour's career, in every capacity in which he's worked in the law, His Honour has been known for his industry, his intellect, his courtesy and his humility. Justice Heiley has been a model judge for this court and a much loved and respected colleague. Have long to enjoy his retirement. The court thanks Justice Heiley for his valuable service as a permanent judge and very much looks forward to his further service as an acting judge and wishes him and Sue well for their future. Mr Solicitor, do you move?
May it please the Court, on behalf of the Attorney General and Mr Yubo Malay, who, as the Chief Justice has noted, is an apology today. I acknowledge that adolescent and well into its adulthood. A place incidentally which is today occupied by Martin Carr rentals. Chambers was then to move to Beagle House in 1983 and to the Qantas building in 1989. Along the way, in 1987, your Chambers was renamed William Foster Chambers. They're not quite prepared to settle into an ivory tower just yet. You and your family moved to Brisbane in 1994 to accept new challenges. Building on the experience from your days with Justice Toohey, you are now embarked upon establishing a most impressive native title practice on Jeddah Chambers in Brisbane. Aside from Mabo No. 2, Your Honour was counsel in all of the most significant native title that coexisted pastoral leases, which led to the possible recognition of native title of the vast majority of Australia. Commonwealth and Yamir, which determined that native title could exist over the sea. In that case, the sea adjacent to Crowell Island.
To Your Honour's service to the law, to justice and to the legal profession over a lifetime in the law. The majority of that time has been in the Northern Territory, has been at the Northern Territory Bar. Your Honour served as an office bearer of the Bar Association, including as its president. The Rights Act was passed by the Commonwealth and it brought in the regime of land claim inquiries that my learned friend, the Solicitor General, has already alluded to. They were modelled on the Fox inquiry that had been undertaken in relation to the Darling River. History shows that Your Honour was successfully rescued and the claim went on. Your Honour's enthusiasm for land claim work was not diminished. That work and the unique jurisprudence that developed in the Northern Territory, fiction of terra nullius, and finally recognised an Indigenous right of native title that existed at the time of sovereignty of Australia by Great Britain, derived from the laws and customs of Indigenous communities, was the foundation of the Native Title Act. Your Honour had by then appeared in over 20 land claims, and so when the Native Title Act came into force, there was arguably no more experience. Your Honour went on to practice in that field and appeared for one interest or another in every landmark case in that jurisdiction. In 1997, Your Honour literally wrote the book, or at least edited and contributed to the collection on the Wick case. I had the privilege of being Your Honour's junior in one of the last native title cases that Your Honour undertook before appointment to the Supreme Court in 2013. That was the native lifetime in a national park held under a lease from the traditional owners. Following the decision in that matter, agreement has been reached between the Commonwealth, the Northern Territory and the traditional owners.
And patience. Your Honour has had a long and great relationship with the Law Society. The Law Society is proud that Your Honour's name appears in the Council Roll of Honour and they down at us during Council meetings. Your Honour has served as Councillor, Vice President and President. As the third Speaker, Your Honour, I'm conscious of needing, but at the Society we've done some research. Your Honour was President or Supreme Commander of the Society during 1980 of a professional indemnity insurance scheme and the establishment of the Public Purposes Trust. The Trust, over the years since its establishment, has funded many important communities. I'm informed that the improvements would have also assisted in your pastime of ship watching from the 6th floor balcony with a pair of binoculars in hand. On Your Honour's appointment, the then President of the Bar Association, Mr. Lawrence QC, observed that as a member of the Bar, you were universally liked by the profession and the court staff. This fondness came by virtue of your decency, courtesy, your sense of humour and your self-effacing manner. Significantly, you are still fondly remembered by many in the profession for the fact that you were approachable and extremely helpful to the junior ranks of the profession. Your Honour has evidently retained those qualities after your appointment, because you were very shortly thereafter universally referred to amongst the profession as Judge Cuddles. Your Honour's courteous and patient approach is afforded to everyone in your court. Counsel, witnesses, and potential jurors seeking to be excused from duty for a range of reasons. Your Honour was welcomed as a Justice of this Court on 1 March 2013. To butcher a mid-1990s Broadway number, how do you measure those years on the bench? It can be done in numerous ways. Mathematically, it is 2,295. In 2013, after being appointed to the bench, Your Honour played for the Chief Justice's the Chief Justice's team lost. The profession and the public has had the benefit of an extended period of time with Your Honour on the bench, given the commencement of the Justice Legislation Amendment Act 2019. The profession has had more time than expected to appear before you.
Administrator, the Honourable Mr Vicky O'Halloran, Mr Craig O'Halloran, Chief Justice of the Northern Territory Supreme Court, Michael Grant, fellow judges of the Supreme Court, the Honourable Minister, Ms Natasha Files, judges of the local court, past judges, including Brian Martin, previous Chief Justice, and Sally Thomas, previous judge, and upstairs Austin Ash, previous Chief Justice. Also, welcome to friends and family, and many of whom have travelled a long way within Australia, and all of you, or most of you, people that I've had a lot to do with on a daily basis almost. Thank you to the speakers for your kind words. Mr Solicitor General, Mr Christop. I better confess, I was told by Sally Thomas in the waiting room before that I should confess that I lied about my age. And that, in fact, I'm 75, not 72, next Thursday. And I don't have to come back. Thank you, Mr McDonald, for your kind words. I didn't realise that I was a Rhodes Scholar, but I do remember Tom Pauling used to appear in a lot of cases against me, and I think he might have given me that tag then. And thank you, Ms Farnell, for going back and reminding me of my success, particularly as a cricketer, and many other things. So I appreciate all your kind words. Special thanks to Debbie Carr for all the wonderful organising that she has done to make this ceremony a success, and to many others of the court staff in particular who have assisted, including my own PA, Mesa. Thanks to others, especially my wife Susan, and to my associates, some of whom are here now. And thank you all for your patience, your assistance and loyalty. I'm especially pleased to have our two older children here, Nicole and George, with their partners and their young children, and also my brother, who I've known since I was 6. So a warm welcome to everyone, and you do include representatives of various groups that I have been part of over the past 50 years or so. They include the Army, they include the mighty Court Jesters tennis team. We can see Claire Martin, Justice Southwood's not here, but Gordon Byrne's here, and John Harrison and Belinda Paspaley, the mighty Court Jesters. Casuarina Hash House Harriers, and I've enjoyed their company ever since about 1976, and I've always felt that running, and nowadays it's walking or limping, with those fellas is a wonderful release from the pressures of work, just getting out there and talking to normal people. Also to the... Also, my dear friend, as a representative of the Wild West Poker Club in Brisbane, is here. Members of the Melville Street Tennis Group, members of the East Point Gentlemen's Tennis Club, fellow sailors, campers and holidaying companions. So I'm really pleased to be here with all of you. When I accepted the invitation to join this court in 2013, I did so with great pleasure, and I said so at the time. In particular, I was already well acquainted with my good friend, the then Chief Justice Trevor Riley, and with the other 4 judges, all of whom I had practiced with at the bar, either against or with them. And I'd known them all professionally and socially. I knew that I would get on very well with each and every one of these people. Since then, the court has been joined by the present Chief Justice, who I keep reminding him I taught at law school. And maybe I didn't do very well, but there you go. And finally, my replacement, Justice Brownhill, with whom I've already also worked at the bar doing some native title work. My original hopes and expectations were and continued to be fulfilled. I could not imagine a happier workplace, a wonderful group of intelligent, hard-working and sincere human beings, all intent on applying their skills and experience to advancing the administration of justice in the Northern Territory. Thank you to each and every one of you for the privilege of working with you. I particularly enjoyed sitting on the Court of Appeal and also on the Court of Criminal Appeal. That has provided a wonderful opportunity to learn how my fellow judges operate and to engage with them in the process of deciding the case and writing the court's reasons. Thank you to the speakers for going back on some of the highlights of my career, so I won't go back to travel over those again. But I'm particularly pleased to see present today George Cridland. Thank you, George, because as one of the speakers commented, I did start here working with Cridland and Bauer after my brief stint with John McCormack. I then joined the Independent Bar, as we've heard, in 1978, and there was John Harrison, who's here, and myself, who joined Michael Maurice, and we were then a bar of three. The bar had already been started by Tom Pauling and Michael Maurice and Ian Barker, but both of them had gone off onto different paths. Since joining the Independent Bar, as has already been mentioned, I've been privileged to participate in its growth, and that has included the formation of the Bar Association, the expansion and then the naming of William Foster Chambers, and then the expansion of additional chambers in the Territory. I haven't done a count, but my guess is that the bar probably numbers about 40 now, a big increase from the meagre 3 when I started. So I am pleased to see some of my old colleagues, as I mentioned, John Harrison, Tom Pauling, Colin MacDonald and Trevor Riley here today. As we've also heard, I had the privilege of working on a lot of land claims with a number of land commissioners, including Justice Toohey, and I had to learn very quickly, and I think I did, about Aboriginal laws and customs. Even though I started working as counsel assisting, I then began to get briefs, and I've always prided myself for the fact that I was able to get briefs from all sides of the litigation. So a particular pride, I suppose, is a success that I had helping the peoples out at the Nicholson River area get their land under the Land Rights Act, and moving a long way forward, just before I was appointed to the bench, helping the Bungala people get their native title down in the Eyre Peninsula in South Australia. I've also been very proud of the pro bono work that the bar has done, and I particularly think back to the day or the week or so when a boatload of Cambodian asylum seekers arrived here. I think about the mid-80s, and Colin MacDonald was instrumental in gathering the then 11 of us at the bar to split up the members of the passengers on the boat, who ranged from aged 4 to 44, and between us we were able to help them fill out their forms, process their applications, and the Darwin community as a whole got on board to help these people and their families, and that's one of those particular moments that I'm very proud of. And as I say, Colin and Trevor was involved in that too, and other members of the then bar. Some of my time, as you've gathered, has involved me being away from home a lot, and Susan reminded me this morning that has enabled her to bring up our 4 children without too much interference from me. And then, of course, my last 8 years as a Supreme Court judge have been truly valuable parts of my life, sitting not only here in Darwin but also in Alice Springs for at least a month every year and once in Katherine. My judicial career has had many highs and lows. It had an awkward beginning when I first appeared on the bench. I had not worked much in the criminal jurisdiction over the preceding 20 years, so I spoke to my fellow judges, including the Chief Justice, about procedures and practices. I studied up the Criminal Code and the Sentencing Act and all those sorts of things before I went down to do my first case. There's one thing they didn't tell me. After I'd heard all the submissions from the barristers, and I very confidently said, "Please adjourn the court," I proceeded to leave the bench. Unfortunately, I walked through the wrong door and found myself stuck in a broom cupboard, where I felt obliged to remain. And I'm not sure whether it was Bridget or James, but I had to sort of quietly ask them to let me know when the coast was clear. I have learnt a lot since then. As a judge, I've been able to continue learning from other people, and that's a practice that I've always tried to follow. As a barrister, I'd always say to my junior or myself, what did we learn from our case today? We learned some good things, some bad things, good things to do, bad things not to do. And work as a barrister and as a judge has provided me, and I'm sure does other lawyers, with a wide range of opportunities over a wide range of matters. In my case, these have included anthropology, as you've heard. In the sentencing regime, we get very much involved in rehabilitation, particularly of youths. We also have a lot to do with mental impairment cases, and we learn about medicine, medical negligence cases, engineering, DNA, other forensic tools, cattle, we've heard before, helicopters, just to mention a few. So the practice that we have in the territory on our court is so wide-ranging, it's very rewarding because we learn about all these things. Having said that, speaking for myself, it's a lot of it information in and straight out again, but there we go. And of course, jury management has been a challenge because we non-criminal lawyers have had no experience at all in managing juries. I do propose to speak briefly about two areas of concern. My major concern relates to the continuing high levels of incarceration of Indigenous members of our community, often over 80% of our prison population. Of the 261 current lodgements in this court, 151 relate to serious crimes of violence. 37 of those, that is about a quarter, involve non-Indigenous defendants. Over 100 of that 151, that is about 3/4, concern Indigenous male defendants, and in most cases involve a serious assault upon his female partner, resulting in serious harm or even death. Concerns about the prevalence of high levels of violence against Aboriginal women have also been referred to on numerous occasions, in numerous decisions of the Court of Criminal Appeal in particular, going well back into the 1990s, and were also referred to in their farewell speeches by Brian Martin as he was leaving from his job as Chief Justice in 2007, and Trevor Riley when he left in 2016. As we know, when sentencing people, we need to take into account a number of factors. Rehabilitation is very important, of course. Deterrence is very important. But sadly, rehabilitation and imprisonment and, deterrence as such sometimes have to play a lesser role than the need to protect the community. And it's often the need to protect the victim of domestic violence that's of paramount importance when we are sentencing a particular offender. And sadly, we sometimes see the same offender coming back after he has spent 2 or 3 years in jail for similar offending on the same woman. And that's obviously tragic. Most assaults, not only in the Northern Territory but Australia and I assume worldwide, involve offenders and sometimes victims who have committed crimes of violence
while under the influence of alcohol and or drugs. Sadly, many of the Indigenous offenders that come before the courts have found themselves addicted to alcohol and or drugs. This is often associated with their inability to improve their lives by becoming fully conversant in English and consequently difficulties obtaining meaningful employment. Understandably, these things have often resulted in their lack of self-esteem and boredom, and consequently the resort to alcohol and or drugs. Sadly, we still need interpreters quite frequently in court to help young people, that is, people between 17, 27 and so on, give their evidence or hear the questions, understand the questions, because although their primary language might be an Aboriginal language, they do not have sufficient understanding of English. In fact, I can see Mr Lawrence SC here. He conducted a murder trial in my early days on the bench involving a murder said to have happened out at a community. And sadly, about 5 or 7 of the witnesses, who are aged between about 16 and 24, all needed interpreters. Whereas the older ones, the grannies, our age I suppose, didn't need that. They seemed to be quite confident. So that's something that stuck with me. That is that these kids really somehow need to be required to, or assisted I should say, to improve their education, consequently to learn a trade, find some skill so that they can then find some meaningful employment. So in short, that is a great sadness that we see from the bench. We've been seeing it apparently for well over 30 years. We only see the cases after the crimes have already been committed, and we only see the more serious ones, of course, and often there's no alternative but to send some people to prison. The second thing I want to talk about briefly is judicial workload. In short, we need more judges. As a barrister, I had no idea of the considerable amount of time that judges need to spend out of court, time to prepare for each case in advance, and time to consider and provide proper reasons for every decision. I recall that when I was the president of the Law Society and later the president of the Bar Association, it was often incumbent upon me to attend upon the then Chief Justice and to make formal complaints about the length of time that some judges were taking to write and deliver their judgments. I now understand why it is difficult for judges to produce their reasoned judgments more quickly. Ideally, a judge should have more time out of court than we do have. Perhaps at least half a day before a matter is heard, and at least a day or two after a matter is heard. The time before to read the papers and then better understand the arguments being put, the evidence, and better engage with counsel during the hearing. The time after, of course, to start drafting the reasons whilst the witnesses are still fresh in your memory and the arguments and submissions are also fresh in your memory. But sadly, that's a luxury we don't have. If we took that time, our listings would blow out significantly. People would have to wait years for their trial, whether it's civil or criminal. This is the case and has been for some time, even though we've been fortunate to have the services of retired judges who effectively have been doing the work of a seventh judge. I'll trouble you with some statistics. This court has had only six, permanent judges since the late 1980s. That is, the last 30 years. After my retirement, we will still only have 6 permanent judges. When my family and I left Darwin in 1994, there were 1,351 criminal listings, over 1,000 here in Darwin and about 250 in Alice Springs. For the last financial year, 2019 to 20, there were 4,967 criminal listings. And for the first 8 months of this financial year, we already have 4,853 criminal listings. That's more than 3 times the number of criminal listings in 1994, when even then, as I say, we had 6 judges. Regrettably, the average time that it now takes for a criminal matter to proceed through the Supreme Court has more than doubled over the last 6 years, from about 125 days as at December 2014 to about 300 days as at December 2020. This means that people accused of serious crimes will have to spend at least 12 months in jail and remand before their case can be heard, unless a judge has considered it safe for that person to be released on bail. This in turn has placed enormous additional pressure on judges to list more and more cases for trial. For the financial year 2018 to 19, the number of sitting days in the criminal jurisdiction was 888. Our present estimate for this financial year is 1,264. That's an increase of over 42% over the last 3 years. That's in addition to the 100 or so sitting days set aside for civil matters. Let me just speak of last month, for example. One of our number was in Alice Springs for the month conducting jury trials, as is always the case. One of us chairs a parole board, which occupies several days every week. 3 of us heard 9 appeals in the Court of Criminal Appeal and in the Court of Appeal. And of those 9, it was only possible to provide extemporary reasons for 1. In other words, there are still 8 decisions yet to be provided. 2 judges were conducting jury trials. 1 was on leave for 2 weeks, and I was writing detailed reasons in relation to a lengthy and complicated civil matter and another matter. And we're all doing the usual sentencing and bail applications and breach applications. In short, we need more judges in order to assist the administration of justice efficiently and effectively in the Northern Territory. I'll now conclude my remarks and thank you for your patience. I have been privileged to progress through various stages of the justice system, much of it here in the Northern Territory, and much of it in the context of the wide range of matters associated with Aboriginal people. As a judge, I've seen great pleasure in seeing young lawyers doing their best to represent their clients, including making novel and sometimes outrageous submissions. I've enjoyed teaching advocacy and enjoyed seeing many young practitioners applying their learned skills in court before me. I think every lawyer who I have taught, perhaps except for the Chief Justice, because he never did anything I taught him, each of my associates now knows that if they appear before court in front of me, they will come along with a chronology. As the Chief Justice mentioned, I do intend to do some work from time to time as an acting judge, but as I've said, the time is ripe now for me to move on, and I thank you all for your kind words and wish you all well. Thank you.
Thank you, Justice Harley. Again, the members of this bench, thank you for your service and your camaraderie during your time as a judge, and we wish you, ladies and gentlemen, the judges of the court invite you to join us for refreshments in the foyer once proceedings have adjourned. Yes, adjourn the court, please.
Silence adjourned. God save the Queen.
Perth.
All right.
Okay.
Okay. Well, you're retiring this week
Yes.
on Friday.
Well, next Tuesday actually,
Next
but the big
Tuesday?
ceremony's this Friday.
Okay.
Yes. And I'm retiring on Wednesday, because I have to, because I turn 72 the next day. And it's a compulsory retirement age. Most judges in Australia have to retire at 70, but the Territory extended the law so that I could stay till 72. So
Right. So
then
basically getting kicked out.
Yep, that's right. They call it statutory senility. By statute under the Supreme Court Act, you're senile once you turn 72.
Do you think, are you ready to retire?
Oh yes, I think so, yes. I think I've had a pretty good career, and it's time to do something a bit different, like maybe sleep in the mornings and not worry about having to come to court every day and maybe sentence people and make some of those difficult decisions. So it'll be good just to relax and do other things.
Spend time with family. What have you got your sights set on?
Oh well, I've got lots and lots of books to read, of course. Little projects like scanning photographs, family photographs. We've got a few grandchildren now here in Brisbane, so we'll hopefully see a bit more of them. And I like the bush, so we'll do a bit more camping. I like playing tennis, so we'll do a bit more of that, and I might even learn to play better golf.
There you go. That sounds like fun. So correct me if I'm wrong, 42 years altogether within the legal industry, is that right?
I guess that's right. It's probably more. It's probably nearly 50, because I graduated in law in 1971. So yeah, what's that? That's 50.
Yeah.
Yes. And I was a solicitor, admitted as a solicitor in early 72.
Okay.
Yes.
Gotcha. Okay, so 18 years in Darwin, I think, altogether?
Altogether longer than that.
Longer?
So
Oh God,
we were here from.
I've been adding up the wrong
That's
sums.
okay. No, we were here from 76 through to 94. So that's 18 years. And then I've been back here for the last 8 years as a judge.
Gotcha.
So
So there was a little break in
a little bit of a
between
gap.
that. Yeah.
Well, we lived in Brisbane, took all the kids down to Brisbane, and I practiced as a barrister down there in Brisbane. So I jumped at the chance when one of my previous best friends, Trevor Riley, who was then the Chief Justice, put my name forward as a possible candidate for this job. And yeah, so I'm pleased I did it. So that encouraged us to come back to Darwin and join all these other smart people on the bench, all of whom I'd known for a long while anyway, because we'd practiced together as lawyers.
And how many years as a justice?
8, yes. About 8 years and 1 week,
Yeah.
yes.
I've always wanted to ask a judge, what is it like doing the transition from, becoming a judge? How different is it, especially at
Yeah.
first?
I suppose there were 2 things for me. One was that most of my work I'd done in what we call civil commercial law, and in fact it's the case for most judges. But here, 90% of our work is criminal law, so that was a bit of a change, and I think it probably took me a while, to get used to some of the nuances of the criminal law. So that was one thing. Another big change was that as a barrister, particularly if you're a Queen's Counsel, you have a big team of people helping you prepare cases. So you have one or more junior barristers, solicitors, whole team of people that help you interview witnesses, prepare submissions, do a lot of the hard work before you actually front up into court. And which is good to have that help, whereas as a judge you really don't have any of that. So we do have associates who are very bright young lawyers, but they're usually just first year out of law school, and so we can get them to help us with some research, but that's fairly limited. And as well as that, most of our associates are flat out doing other things, like administrative things like rearranging court lists and talking to solicitors and things. So they're probably the two big changes. So it's a bit of a shock now as a judge, having to sit down and do a lot of your own research and writing out your own reasons for decision and that sort of thing.
And working in Brisbane, you know, compared to the Territory, how would you describe that?
Yeah, well, interesting. And one of the reasons I went down there was to see how I would go in the big smoke. When I left here, there were two QCs in Darwin, in the civil area. The other one was Trevor Riley, who became Chief Justice, and me. And it was Riley and Hiley, and people would often confuse us and give us each other's briefs, and he'd steal my briefs and that sort of thing. But then when I went to Brisbane, there were 60 QCs. So all of a sudden I had this funny feeling of jumping into this great big pool of a lot of competition, 60 QCs instead of just one. And that was pretty daunting, I suppose, because I hadn't come from Brisbane, so I didn't have any contacts down there. But I did find that the people down there were very friendly, and I picked up some work down there. But that also was one of the things that led me into doing native title work, because I had done a lot of land rights work up here since the late 70s, and native title really only began in about the mid-90s, which was about when we moved to Brisbane. So I had a lot of people, solicitors would ring me up and ask me to do native title work, and so I did a lot of that, and I specialised in that.
Yeah, I was reading your, you've done, you know, native title matters all over Australia,
Yes.
so the Larrakia claim of Darwin, can you
Yes,
talk
yes.
us through some of the other land claims?
Yes, yeah, because native title was a fairly new thing after the High Court's decision in Mabo, and it really meant that Aboriginal people could put forward a claim to land anywhere in Australia, wherever they were from. And the first case, one of the first test cases, in fact, was of the sea off Croker Island here, because it was a bit of a test case to see whether you could have native title to the sea. So that was an interesting test case. And another one I did at the same time was down in the Murray River, and that was called the Yorta Yorta case. But it was an interesting case because, as you could well imagine, people have lost a lot of their language and a lot of their practices and traditions further south because of the influence, I suppose, of settlement. Whereas, so the big difference, big contrast between the level of knowledge down south, so to speak, and the level of knowledge up here. Yep, so I've been lucky. I've had work really all over the country. So
Some historic
it's
cases there.
yeah, and also I've been privileged to be able to work for all different sides. So, and I think one of my highlights, I've had a few highlights, but particularly where I think that I've helped the Aboriginal people get their land title. One was the Nicholson River land claim, which was in about 1985. Nicholson River is quite a large block of land if you look at the map on the Territory side of the Queensland border, just south of the Wallagrang station. But so I was involved in running that one, and just before I joined this court, I was doing a big native title case in South Australia, just north of Port Lincoln there, and for the Aboriginal people down there. So I guess it's particularly rewarding to pick up a case for some people and to manage to win the case. I mean, I did work for other parties, and I've always thought it's good for a barrister to work for all sides. And so some of the other Territory cases I did here were for the Northern Territory Seafood Council and the pastoralists and that sort of thing. And I've worked for mining companies and for governments, so it's been a good spread.
Yeah, I saw your comment that you're always learning.
Yes, yeah. Yeah, it's been a bit of a motto of mine. I've always said it to junior lawyers that I've worked with, is to every court case, just try and learn something, and particularly maybe look at your opponent. And sometimes you can learn a new trick or a new idea from your opponent. Sometimes your opponent might be pretty crappy, and you might think, well, you know, I won't do that. All right. So yeah, I think that's a wonderful thing.
Would you say you're still, even this year, you've learned a few things?
Yes, I think so. Also, you learn things about all sorts of other disciplines because, again, I'm probably going back to more as a barrister, but one week you might be doing a personal injuries case or a workers' comp case. Someone's damaged their back, so you learn all about the L5S1, disc space at the back, and then next week you might be doing a case about a bridge that's fallen down, so you learn all about bits of engineering and metallurgy. And next week you might be doing a motor car accident, or we've had a few of these in the criminal jurisdiction where you have to get the experts working out what sort of speed the car was going and what direction. So that's and medicine, that's the other one. We did a lot of professional negligence cases, either for or against doctors, and so it's just even though it's just law, I mean, you're learning so much about all sorts of other disciplines.
And it's also never a dull day.
No, there's always something. You never know what's going to pop out of the woodwork, and sometimes good, sometimes not so good. Yeah.
And pro bono work.
Yes.
You assisted in the first boat of asylum seekers from Cambodia?
Yes, yeah. So that was terrific. At that stage, we had just one set of council's chambers, William Foster Chambers, and there were 12 of us, and 11 of us basically divided up the boatload of 50 or whatever it was and took 4 or 5 each, and we sort of helped these people fill out their forms, and then they were accommodated out at Berrima for quite a while, and there were lots of local church groups and other social groups were there to help these people settle in. But that was something to be pleased with. That really the whole bar. The reason the 12th didn't get it was that the 12th was briefed by the Commonwealth against the asylum seekers. So, but it really did. It was one of those great things where you had all of the barristers joining together to help these people.
Very memorable.
But it was. I mean, unfortunately, they all got shipped off to Derby, north of Broome, to a camp, and at the time we thought that might have been a deliberate decision by the Commonwealth Government of the day to get them away from us and away from a lot of the help that they were getting locally. But that was good. Otherwise, the pro bono work, I think, and that's a good thing about the bar. I think barristers are encouraged, and solicitors do, to do a lot of pro bono stuff, and which, and that might include helping unrepresented people, particularly in the Court of Appeal, to put their arguments, and so that they've got a better chance of not upsetting the judges and putting forward a good case.
And I was also reading, when you first became a judge, you were sort of saying, you didn't realise how much work they do outside of the actual courtroom, and considering and providing proper reasons for every decision and stuff. So
yes,
was it? Well, it's obviously a very demanding profession.
Yes.
Is it hard to sort of juggle your family life as well?
Yeah, I think so, and probably my wife would be the person to ask about that. But I think it is, particularly because you do work extra hours. I try not to work on weekends in here, but I'm always taking stuff home every night. But at least 2 of the other judges, if I come in on a Saturday or Sunday, they're always here, and it's just the demand is to try to cover what you've done last week and make some notes about what you've done, and then prepare for next week. So it's a big workload, and unfortunately there aren't enough of us to go around. There were 6 judges way back in the late 1980s, and there are still only 6 judges, and the listings have tripled. So we really need more resources. Yeah.
I was reading that.
Yeah.
Yeah, I was reading that you're saying the time is right for the appointment of at least 1 more judge.
Yes, but that's a matter for government, of course. But unfortunately, one can't expect the judges to just keep on working all their spare time. I mean, people think that, we've just done a case today and the judge should be able to bang out the decision tomorrow or next week, but it's not that easy. So often, no, and especially as I said before, if you don't have the help of other barristers or solicitors and helping you, you're pretty well much on your own. Having said that, we do get a lot of assistance from barristers, so when they appear before us, often they will give us some good submissions which will help us when we're drafting our reasons for decision.
Yeah, these figures here that I saw here, you know, when you first came here, when you left Darwin in 1994, there were 1,351 criminal listings.
Yes. And
Then
now we're,
last financial year,
we're
4,967
yeah,
criminal
listings.
listings.
Yep. So 3 times. Yeah,
With
statistics.
the same
Yeah.
amount of judges.
Yeah,
Oh
yeah.
my goodness, no wonder
That's,
it takes so long.
Well, that's right, and that's the criminal side, and of course that's not counting the civil side. Civil side has dropped off a little bit because more and more civil cases now get settled or mediated. But the criminal side, yes, what that means is that would be jury trials, sentences. So basically we do about probably an average of maybe 3 or 4 jury trials a week. So that's 3 or 4 judges every week for about 49 weeks of the year sitting in jury trials. And then unfortunately that doesn't give us much time to write our decisions on other matters or even on the jury trials, because sometimes you have to sit back and hear arguments about something and then write reasons for that. So we don't have much time for other things. So and sadly, although we're very proud of our record, generally people can get a jury trial dealt with here within about 12 months of the date when the crime has happened. But interstate, it's more like 2 or 3 years. So we're very proud of that record, but we won't be able to keep that up because something's got to give, and unfortunately it will take longer for jury trials to come on. That then puts more pressure on the jails because people will either be in custody if they're serious offenders pending their jury trial, and so they might be 18 months waiting for their trial. Pretty bad if you're innocent. Or there's greater pressure to give people bail, and as you know that can sometimes be risky, so it all exacerbates the problems.
And also reading your major concerns or disappointments with the high level of incarceration rates. Could you talk us through some of those points?
Yes. Oh well, we often hear the fact that a large percentage of the prison population are Aboriginal people, males, and I think the last figure I heard was about 87–90%, something like that. But sadly, it's a reflection of the high level of criminal activity that we see in that area, and sadly a lot of it's domestic violence and drunken domestic violence, and it's a real problem. I think I found some statistics, something like I think 100 of our 260 or something current listings are in that category. That is Aboriginal, usually Aboriginal male, accused of some violence against another person, often. So that's really sad, obviously, and it's something that seems to have continued for a long while, and unfortunately by the time it gets to us we can't do anything about it. We just do the serious crimes, and generally we have to send people to prison for that. It's different for the local court. They deal with the less serious things, and they've got a lot more sentencing options, but we don't have many options. So on the one hand you got to protect the community, protect the woman. On the other hand, of course, you've got to try and recognise that the person's going to be out of jail sooner or later, and so it's important to have that person rehabilitated and hopefully supported with programs designed to fix their drinking problem or their family violence problems and that sort of thing. So.
And being obviously a seasoned judge to all of this, is there times though that you have become quite emotional with the case, or has there been a time that you?
There probably has, but unfortunately you probably get a bit used to it. And some of the domestic violence ones obviously are fairly nasty. The worst ones I think are the kiddie sex ones. I mean they get very hard, and unfortunately a lot of them go to trial because the accused person will not plead guilty, and a lot of them are historic cases. So they're the really tough ones.
Those cases make me
especially where you've got, yeah.
Do you feel emotion when you do it, or do you just have to do your job?
I think you do. You feel a bit, yes, yeah, you do, but I guess you get a bit hardened to it after a while, and you have to go home and put it behind you. Yeah, no, that's one of the hardest things of the job, I think, is just dealing with those cases. And
what about murders? You've done obviously plenty.
yeah, I've only done a couple actually, and in a way, they're relatively straightforward. I mean, often it's just a matter who done it, and what was the person's intention when he or she did do it. And usually there's a bit of background, and the victim's usually a partner or a friend or something like that. So they're much more straightforward than, say, the rape cases, because a lot of the rape cases turn down to the question of consent, and they're difficult as well because often there's intoxication involved on both sides, and whether or not usually the bloke knows that the woman can't be consenting because she's drunk or whatever it is. So they're pretty sad cases, and again the woman has to come forward and give evidence and make those decisions as to whether or not she's going to proceed and be cross-examined, all that sort of thing.
So looking back, any regrets? I don't know. Are you happy with you?
Oh, yeah, that's been pretty good, really. Yeah, I think one of the most difficult tasks, I think, is sentencing. It's just getting that number right. So I think I've had about 3 or 4 successful appeals against my sentences, and that's the beauty of our system, that if there's an appeal system, and the Court of Appeal of 3 can overturn us, but so I think 2 of them I've been too light and 2 of them I've been too heavy, so it's not too bad. But that's part of the system, which is good. We have some funny cases, and I don't know if you're going to ask me about that, but you know, occasionally there's just some cases that you have to go home and laugh about or tell your mates about. And you know, one was about this middle-aged couple who decided to make their own methamphetamine in Alice Springs, and the bloke had been to the chemist, and all the different chemists, and acquired about 100 tablets of whatever it is, Sudafed or something like that. And I learned, another thing you learn, you can go on the internet, you can learn how to make amphetamine apparently, and you get these soda water bottle things that you know, you have that soda siphons for, and you mix it up and you put bits of batteries and you put all this sort of stuff in there, and so this couple was doing this when the cops came around, and the lady had this jar of stuff, well, this bottle, she just mixed it, and she hid it underneath the bench in the garage, and the copper came in, but she knew that it would blow up if she didn't take the lid off within half an hour or something like that. So she was getting very nervous because the cop was there and the lid was on this thing, and she just had to confess after a while. So I've learned a lot about how to make methamphetamine, and the fact that, yeah, it might blow up and apparently even though they'd had used 100 of these tablets, they only made something like a gram or something of methamphetamine. But you wonder why people do these things. But anyway, that's just a funny case.
Oh,
but I'll tell you one more. Another one, I think it was in the press recently, about some fellas from Tiwi, and they came out by boat to pick up some cannabis here, and on their way home they got a bit drunk because they were rewarded with some rum. So they followed a light that they thought was a buoy that they normally guide themselves by at night time. So they saw the light, and that would normally get back, but they didn't realise it was a light on the ship, and the ship was heading west. It was a destroyer actually, and they followed this light all the way across the north coast of Western Australia until they ran out of petrol. So you can imagine these fellas out there with a boat full of cannabis and rum at 5 a.m. in the morning stuck to.
Have a little
Anyway.
chuckle on the chair.
So yeah, that's right. So yeah, we do get a few amusing ones, which is good. Good for the sense of humour.
You need them every now and then.
Yeah, that's right.
Oh well,
Yeah.
I'm pretty much done. Is there anything else
Good.
you wanted to add, or just something to sum up on?
No. Well, actually, one thing, a bit of a hobby horse of ours is sentencing remarks. Often the press will just find these sexy headlines. Murderer gets out after 5 years and that sort of stuff. And I know they sell papers and encourage people to watch your TV program, but often you've really got to read the fine print, and more often we do publish all our sentences, or all our complete details of our sentences on the internet. But so that's something that, yes, we do get annoyed about sometimes, because the average member of the public will often just see the headline. It'll say, rapist gets off, or killer gets off, and that sort of stuff. And but you really got to read the reasons to discover actually he wasn't convicted of rape at all, or what it was. But, so that's something that's a bit of an ongoing issue with us.
All
And
right,
poor old Xavier often has to deal with those ones. We ring up Xavier and say, ring up.
Which is probably about me all of the time.
Yeah, well, I know. I've never heard any problems about you
good.
or Channel 9. So.
Good. Probably NT News.
Not allowed
is
to
there like
say.
a sentence? Maybe we'll end with the last sentence you want to reflect, to describe your career.
My career. I'm so privileged, so lucky to have had the opportunities to go through school and university, and to engage in such a wonderful career. And I put a lot of that down to, I guess, parents and my upbringing, and all the fabulous people that I've been able to work with right throughout the whole process. It's just been fantastic.
And I didn't ask. This was supposed to be my first question. Last question. What made you want to get into law in the first place?
Oh, money, probably. Isn't it? Yeah, sorry, I shouldn't have said that. I don't know. I was either going to be a mathematics professor, because I'm good at maths, or a lawyer, or a fighter pilot. And somebody said to me, you make more money being a lawyer, so there you go.
Brilliant. Thank you. We'll just grab some. Do you want me to take the mic, Coppers?
Yeah.